Welcome everyone to the Dolphin School of Real Estate channel. We are back again with yet another quiz from Section 9, Titles, Deeds and Ownership Restrictions. Without wasting any time, let's dive right into the questions. Alright, the first question is: while a one-year lease is in effect, the tenant dies of a sudden illness. In this situation, what happens? Here are your options. Option A. The lease automatically terminates. B. The tenant's estate has the option of canceling the contract. C. The landlord can record a lien against the leased fee interest. D. The tenant's estate is still obligated under the lease. Consider each option carefully and choose the one that accurately represents the course of action in this scenario. I am going to give you guys some time to think about it. Alright, let's reveal the correct answer now. So the correct answer is D. The tenant's estate is still obligated under the lease. A valid lease creates obligations that survive the death of the landlord or tenant, with certain exceptions. A tenant's estate remains liable for payment of rent if the tenant dies. The landlord's estate remains bound to provide occupancy despite the landlord's death. Alright, let's test your understanding of actual notice and its significance. Take a moment to carefully consider your answer. Here is the question for you. Which of the following defines actual notice? Option A. It is notice published in a newspaper. B. It is knowledge one could have or should have obtained. C. It is notice explicitly stated in a legal document. D. It is knowledge received or imparted through direct experience. Consider each option carefully and choose the one that accurately defines the concept of actual notice. Alright, it's time to unveil the correct answer. The definition of actual notice is D. It is knowledge received or imparted through direct experience. The term notice is synonymous with knowledge. A person who has received actual notice has actual knowledge of something. Receiving actual notice means learning of something through direct experience or communication. Thus, a document in itself cannot be actual notice. It is the seeing of the document that makes it actual notice. Alright, next one. The purpose of a deed restriction is to enable an owner to specify. And here are your options. Option A. The form of ownership in which a property may be held. B. How long a property must be owned before it can be legally transferred. C. What groups of people are legally excluded from future ownership of a property. D. How a property may be used and what improvements may be built on it. Carefully analyze each option and choose the one that accurately describes the purpose of a deed restriction. Alright, it's time to unveil the correct answer. The purpose of a deed restriction is D. How a property may be used and what improvements may be built on it. Well done to those who selected option D. Deed restriction is a limitation imposed on a buyer's use of a property by stipulation in the deed of conveyance or recorded subdivision plat. They may apply to a single property or to an entire subdivision. A developer may place restrictions on all properties within a recorded subdivision plat. Subsequent resales of properties within the subdivision are thereby subject to the plat's covenants and conditions. Alright, let's test your knowledge about the significance of recording a deed. Here's your question. What is the function of recording a deed? A. It makes the deed valid. B. It causes title to pass. C. It gives constructive notice of ownership. D. It removes all prior recorded encumbrances. Examine each option and choose the one that accurately defines the primary function of recording a deed. I hope you have made your selection. Now let's reveal the correct answer together. So the correct answer is C. It gives constructive notice of ownership. Recording is not necessary to make a deed valid. However, it is in the grantee's best interests to do so. Recording the deed gives the public constructive notice of the grantee's ownership. Alright, next one. Here's the question. If property alpha has a court-ordered easement across property beta in order for alpha to have access to a public road, the easement is in Option A. Easement by prescription. B. Personal easement. C. Easement by necessity. D. Easement in gross. Examine each option and choose the one that accurately describes the type of easement in this scenario. Alright, it's time to unveil the correct answer. The type of easement in this situation is Option C. Easement by necessity. An easement by necessity is an easement appurtenant granted by a court of law to a property owner because of a circumstance of necessity, most commonly the need for access to a property. Since property cannot be legally landlocked, or without legal access to a public thoroughfare, a court will grant an owner of a landlocked property an easement by necessity over an adjoining property that has access to a thoroughfare. Okay, question number 6. A property owner who is selling her land wants to control how it is used in the future. She might accomplish her aim by means of Option A. An injunction. B. A deed restriction. C. An easement. D. Land trust. You know the drill. Consider each option and choose the one that accurately describes the method a property owner can use to control future land use. Alright, the correct answer is Option B. A deed restriction. A private party who wants to control the quality and standards of a property can establish a deed restriction. Deed restrictions take precedence over zoning ordinances if they are more restrictive. Now, let's test your understanding of the nature of a mortgage lender's interest in lien theory states. Here's the question. In a lien theory state, what kind of interest does a mortgage lender have in the lien property? Option A. A possessory interest. B. A tenancy by mortgagee interest. C. A legal interest in a pro rata share of the property. D. An equitable interest. Think through each option and choose the one that accurately describes the nature of a mortgage lender's interest in a lien theory state. Okay, I hope you have your answer ready. So the correct answer is D. An equitable interest. A lienor generally has an equitable interest in the property, but not legal ownership. The exception is a mortgage lien on a property in a title theory state. In these states, the mortgage transaction conveys legal title to the lender, who holds it until the mortgage obligations are satisfied. During the mortgage loan period, the borrower has equitable title to the property. Alright, question number 8. Here's the question. A person wishes to convey any and all interests in a property to another without assurance of the property's marketability. This party would most likely use which of the following types of deed? A. A sheriff's deed. B. A special warranty deed. C. A partition deed. D. A quitclaim deed. Take a moment to think about it. Which deed seems most fitting for this situation? I am going to wait for you to decide and we will reveal the answer together. Okay, I hope you have decided on your answer. Let's check if your answer is correct or not. So the most suitable choice for conveying interests in a property without marketability assurance is D. A quitclaim deed. Great job if you picked option D. A quitclaim deed is the go-to when someone wants to transfer interests without dealing with marketability concerns. Alright, here's the next question for you. A homeowner defaults on his mortgage loan. In the subsequent foreclosure action, the lender takes title to the liened property directly instead of initiating a court-ordered public sale. This is an example of Option A. Strict foreclosure. B. Judicial foreclosure. C. Non-judicial foreclosure. D. Deed in lieu of foreclosure. Take a moment to think about it. Which one fits the bill? Alright, time for the answer. The situation described, where the lender gets the property directly without a public sale, is an example of the first option, strict foreclosure. If you went with option A, you're right on the track. Strict foreclosure is a court proceeding that gives the lender title directly, by court order, instead of giving cash proceeds from a public sale. On default, the lender gives the borrower official notice. After a prescribed period, the lender files suit in court, whereupon the court establishes a period within which the defaulting party must repay the amounts owed. If the defaulter does not repay the funds, the court orders transfer of full, legal title to the lender. Alright guys, we are at the end of the video for today. Let's explore the statute of frauds in real estate. Ready? Let's jump in. Here's the question. In accordance with the statute of frauds. Option A. Leases in excess of 1 year must be recorded to be enforceable. B. Oral leases are not enforceable. C. A 5-year lease must be in writing to be enforceable. D. An unwritten lease is fraudulent. Take a moment to think about it. Which statement aligns with the statute of frauds? Alright, let's unveil the correct answer. According to the statute of frauds, the accurate statement is option C. A 5-year lease must be in writing to be enforceable. Generally, a lease for a period exceeding 1 year cannot be oral but must be in writing to be enforceable because of the statute of frauds. Well guys, that is the end of today's video from Section 9, title, Deeds and Ownership Restrictions. I hope you enjoyed today's video and found it helpful to prepare for your license exam. We offer different types of courses such as pre-licensing, post-licensing courses, and we also have numerous studying materials to help you ace your real estate exam. You can visit our website, dolphinschoolofrealestate.com, to know more about us and the courses we offer. Also, please don't forget to like, share and subscribe to our channel. We will see you in the next one.